Hi, my name is David P. Shapiro. I'm a San Diego criminal lawyer. I'm also the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California. My firm helps good people regain control of their future when charged with a crime. And today I want to discuss with you the crime of being a felon in possession of a firearm. As other videos that I've done have alluded to, when you are convicted of a felony, you lose your ability to possess a firearm for life. May be different if your felony gets reduced to a misdemeanor in the future, but let's assume you have a felony on your record. Under no set of circumstances can you possess a firearm. So what we see when someone's charged as being a felon in possession of a firearm usually involves one or two situations. It usually involves if you're on probation for a felony, probation does a search of your home, and they find a firearm. Well, naturally, the firearm is not going to be registered to you because you wouldn't be able to register it to yourself as a convicted felon, but it might be registered to somebody else. It may be hot. It may have the serial number shaved off. There's many different ways it could be. It could also be something you might have had registered to yourself years ago and just never turned it in and fell through the cracks as far as paperwork goes. But the reality is, if you're convicted of a felony, you cannot possess a firearm in the state of California. Other type of situation is that the allegation is that a firearm was used in the commission of a new offense. So you get hooked up on a new offense and it's alleged that you used a firearm, even if everything else, far more serious charges are unable to be proven, or if you're in fact factually innocent of those charges. You still have a problem if they can prove that you possessed a firearm. So let's say, for an example, you're accused of flashing a firearm at somebody or shooting at somebody, and you're proven, factually innocent of that. That was totally made up. But as a result of that investigation, cops hit your house, they find a firearm in your house. May have nothing to do with those allegations. You're going down and you got a problem on the felon in possession of a firearm. We also see it in situations where you may have no record, but you might have controlled substances on you and are nearby a firearm. That can be charged as a felony as well. So definitely something to keep in mind. The best thing you could do when under investigation or being charged for being a felon in possession of a firearm, keep your mouth closed. Don't admit to things. Just politely decline to answer any questions before, next thing you know, you start admitting that you knew about the felony conviction. You knew you couldn't have a firearm. You knew that that firearm was yours, or that it was yours, or that you were using it. And you really hurt your chances of having a successful outcome in court. The next thing you could do is hire a quality, locally experienced criminal defense law firm to help you through this process, because the fact that just by the nature of being charged as a felon in possession of a firearm, that usually means you have a prior felony conviction. So the punishments usually go up over time. So you need the best people to represent you, the best staff, the best attorneys. We believe we are one of the best law firms, if not the best law firm in San Diego, dealing with criminal defense. And if you want our help, we encourage you to give us a call, 619-295-3555.